monthly meeting. From this month, we are also trying to bring in our IR Guru conversations with IR Gurus, along with our monthly Labourlaw update. So the first 10 to 15 minutes would be our Labourlaw update, followed by the conversation with IR Gurus. We have Mr. Suresh Bose, CHRO Jindal Stainless, as our guest for this week. So without any further delay, let me just get started with the update so that we could start the conversation thereafter. There's just one amendment that has come about this month, and it is the amendment to the Contract Labour Act by the Himachal Pradesh government, where instead of 20 persons, if the provisions of the act applies only if more than 30 persons are engaged or 30 contract laborers are engaged. So that's the only significant amendment that has happened this month. Moving on to circulars and notifications, the ESI Corporation has issued a circular. As you would have seen, the ESI Corporation had put in a special scheme for the COVID-affected employees, where they said anybody who has been on the rolls or been registered with the ESI Corporation for 3 months and had paid contribution for 70 days would be eligible for certain benefits. They have reduced this requirement from 70 days to 35 days, and they have issued a circular in this regard. The second one is about Provident Fund, where the EPFO has increased, as you know, from 2021, the benefit under the EDLI scheme has been increased. This circular that they have issued is with regard to the same. The crux of it is more with regard to exempted. So many employers have taken exemption from the EDLI, and it's with another insurance company that they have. So the circular has asked all regional offices to ensure that exempted employers have increased their insurance coverage to match the enhanced limit. So as I shown in the last screen, the maximum benefit now is 7 lakhs and the bonus is 2.5 lakhs. So they want to ensure that additional insurance coverage has been taken by all employers in this regard, and it is sought to be covered in this circular. So instructions have now been issued. So all employers who have exempted EDLI scheme would need to verify whether their insurance policy is accordingly been modified. The EPFO has issued a clarification recently on NEEM trainings. Many queries have come. This, for sake of people who may join in late, we would be taking it as one of the last items of today's meeting. On the quiz session, the provisions of the OSH Code 2020, it's applicable to which of these, or is it to all of them? That's the question for this month. Please do share your answer in the chat box. We would be giving the correct answer at the end of the program. In our international labor law news, what we have is that Belgium has announced a 4-day week. So you work for 4 days and you take a long weekend of 3 days, or it could be a midweek off as well, where instead of 8 hours, employees will work for 10 hours. They have in fact said that this can be implemented with the union's acceptance and could be done. The other aspect that they brought in, especially for not just all employees, is that beyond office hours, they can't be contacted by email, SMS, or any kind of digital messaging. That there's no requirement for employees to reply if they are, and the employees have a right to disconnect beyond their normal working hours. In the knowledge corner of this month, what we have tried to look into, or what we are going to look into, is about assistance. So normally, when you charge sheet an employee and then you have to hold a domestic inquiry, question comes: the employee, is he entitled to an advocate assistance, or is it only a delinquent employee that he is entitled? Recently, Supreme Court has, there are case laws on both sides. In one of the recent case laws, the Supreme Court has said that there is no absolute right. So unless your standing orders or rules or regulations explicitly provide for an advocate assistance. There is no requirement for an advocate assistance, and merely because an advocate assistance is not provided, it will not mean that the inquiry will stand vitiated. Another earlier judgment of the Supreme Court of 93 is even when the company standing order recognizes such right, only you will be entitled to it. So your standing order should specifically provide for it, has been held by the Supreme Court. But this, we take it as the norm that we all recognize. But if you look at it, there are also other case laws where the courts have gone beyond it. So if the management representative is a lawyer, what happens? So if your management representative is a lawyer, then the employee can also request for assistance. Similar cases that of this where the army rules do not provide for it, but the person who was representing the army was knowledgeable legal person, and therefore they said you need to provide for assistance. So the courts have taken different views on this aspect, and it is not that you only need to be even in fact a legal person. So there is a cases where the person who represents the management, if he is sufficiently trained or he has the exposure, though he may not even be a lawyer, but if he's all along been holding disciplinary actions and things, there have been a line of judgment. I'm talking all these are only Supreme Court judgments where they have said you may need to provide. Similarly, where the charges are complex and has questions of law is involved in the inquiry. In such cases, again, courts have held that the employee will have a right for advocate assistance or an outsider assistance. So yes, primarily, if you look at it, the law is that your rules, standing orders or regulations should provide for it. Other than that, they cannot. But the exception to this could be this when an employer is represented by a legally trained mind, or if the charge sheet is very complex involving legal questions, then you could, or then the employee could demand and he should be provided for legal assistance. These are the exceptions, but the general rule is advocates are not welcome in domestic inquiry. Moving on to Know Your Court session of this month. Normally, if you look at it in a collective disputes under section 2K, the government has to refer. These are the issues that we are referring, and those referred issues alone will be adjudicated by the labor court or tribunal. That such a reference is done away with under the new IR code. So there's no requirement for any reference under the IR code. You raise a conciliation ends in a failure, the employee or the union rather, or collective body of employees could take it up directly to the industrial code that they propose under the new IR code. This could be helpful for some of your employees where the ESI corporation delayed reimbursement, medical reimbursement of an insured person. The Consumer Disputes Forum in Mohali has ordered for payment of fine by each of the employees of the ESI corporation. Officers of ESI corporation have been asked to pay fines to compensate. It's more of a compensation, not fine, I should say. Compensation to the employee who did not receive the medical reimbursement on time. So somewhere your employees could benefit by such a proceeding wherever there's a delayed claim. In the case law session, there are two case laws that we are trying to look upon. One which has been heading the headlines is about damages under the Provident Fund Act, where the Supreme Court has held that mens rea is not required. In fact, it's only in the recent past, if you look at it, there are a few case laws of Supreme Court which said that an element of mens rea, that is the intention to defraud, should be there and it should be recorded. In such cases, damages cannot be levied. Now the Supreme Court, two judges of Supreme Court have given a view that no, mens rea doesn't need to be looked into, and for this purpose they have looked into judgments under various other enactments. In fact, they have watered down the position both under the PF Act and the ESA Act. So both mens rea is not required is what the Supreme Court has concluded. But it doesn't mean that you cannot challenge damages. If there are other mitigating circumstances, you can certainly challenge damages. So it is not that if you made a belated payment, damages is automatic either under the ESA or PF. If you're able to show mitigating circumstances, certainly courts can waive the damages. Once again, this judgment also has been doing the rounds. It's been reported that a majority settlement is not binding on a minority group, etc. Factually, there is a distinction on this aspect. It is not so. If you look at it, it's a case of where the contract laborers wanted a uniform policy in respect of wages and allowance and everything, and the tribunal allowed it, High Court allowed it. The settlement which was signed with the majority was not pertaining to this. So it's in that context that the Supreme Court said that a settlement with the majority will not bind the minority, because on the facts of this case, the issue was that the settlement did not deal with issues which were being adjudicated by the tribunal. And it is in that context that the settlement entered with the majority employees union was held to be not binding on the minority response union. So it is not that the Supreme Court has said that a settlement of majority will not bind a minority. That position has not been watered down by the Supreme Court, though that's how it has been widely reported. So we have our complaints calendar for the month of February 2022. When we share this PPT, you could have a look at these and ensure that your establishments comply with these requirements in the month of March. The quiz question, your answer is all of the above. So your Occupational Safety Health Code does cover all of them. Maybe some parts are not applicable to certain types of categories of establishments. So whatever relates to factories is only relatable to factories, but other provisions could be applicable to all of the above. So the OSH code is not specific only to factories. Now coming back to the last segment, where, as I said, what we are going to take up is on the clarification of NEEM trainees. This is exactly an extract of the Provident Fund Organization's circular. First and foremost, if you look at clause A of the circular, they say that the regulation 15.2 of NEEM regulation is ultra vires the provisions of EPF Act. Fortunately or unfortunately, the EPFO doesn't have the right to say what is ultra vires or what is right. So it's certainly a very biased view that has been taken. In one part, they do say that student trainees are not required to be engaged. And the other part, they say they could see who's a student trainee and who's not a student trainee. What has been lost sight is NEEM regulations is under the All India Council for Technical Education, AICT has framed. Every NEEM trainee is a technical education student. You cannot distinguish between one student and the other. It cannot be distinguished on the ground that, oh, this student was covered under the Provident Fund Act. Now he has become a student. Therefore, I will extend Provident Fund to such student. It is impermissible. There are umpteen number of cases where you would have seen that a person could be working, he could take a break, go back to his studies, and then come back to work. So similarly, a NEEM trainee also could have worked as a contract labor, casual labor, or even a permanent labor in some factory where PF was being paid. He would then could have decided that he wants a formal educational certificate, and therefore he could have joined a NEEM regulation training, and as a result of which he becomes a student of the NEEM AICT program. And being so, once a student, it doesn't mean, oh, till yesterday he was working and he can't be a student today. Therefore, the EPFOs completely lost sight of this fact. They seem to be under the impression that they would be the last, they would have the last word on this. But as we have already discussed in our earlier programs, this issue is now before the Madras High Court. Whether the EPFO's circular is right or wrong, we need to wait and see. But in our view, This is not right, and there is no requirement to pay contribution on named trainees who are merely students, technical education students, nothing more. With that, we come to the conclusion of this month's session. We hope to see you on 26th March at 4 p.m. Thank you.